How to maintain rights of residence in the UK. To maintain rights of residence in the UK means that family members of EU nationals, settled people are those under immigration rules, who have come to the UK on the basis of that relationship may be able to stay in the UK if that relationship collapses or if it comes to an end. Retained rights of residence is set up under the Immigration, European Economic Area, Regulations 2016, EU regulations, for the family members of EU nationals in the UK. Under the immigration rules, there is a distinct application to be made for the victims of domestic violence. How can you keep hold of your rights of residence in the UK under the EU regulations? The UK has an obligation under Regulation 10 of the EU regulations to authorise non-EU family members to apply for retained rights of residence. In order to apply to hold rights of residence in the UK, the circumstances listed within Regulation 10 must be met. Applicants are eligible to apply for retained rights of residence in the following circumstances: where a wedding or civil partnership to the EU sponsor has broken, with a divorce or dissolution. The EU sponsor has deceased, and the applicant had resided in the UK for at least 1 year before demise. The applicant is the offspring of an EU national who has died or left the UK, or the child of their spouse or civil partner, or former spouse or civil partner. They were in schooling when that person died or left the UK, and they continue to be in education. The applicant is the parent and has guardianship of a child who has a retained right of residence because they are in schooling in the UK. There are further obligations if the applicant is divorced from the settled sponsor or has finished their civil partnership with them. Sufferers of domestic violence may also be entitled to apply. However, the EU regulations only provide for a retained right of residence to former spouses and civil partners. There is no foundation for a strong or unmarried partner to retain a right of residence for motives of domestic violence. How can you retain rights of residence in the UK under the immigration rules? There is a distinct application for victims of domestic violence under the immigration rules. The domestic violence obligations apply to the spouses, civil partners, unmarried or same-sex partners of British citizens and settled persons. For the intentions of retaining rights of residence in the UK on the basis of domestic violence, the applicant must be 18 years and over to be suitable for leave as a partner. Abuse can include but is not limited to mental, physical, sexual, monetary and emotional abuse. An individual who does not have satisfactory lodging or any means of attaining it, or they cannot meet their vital living needs, is considered deprived. These people may also be suitable to apply for retained rights of residence in the UK. For all other motives that a non-EU national's relationship has broken down with their settled sponsor, they will be permitted discretionary leave to remain by the Secretary of State or should take into account making a fresh application under a separate category. This can be an important administrative errand, and you will need to submit the accurate documentary proof. The UK immigration rules are multifaceted, and a legal representative can help make sure that your rights of residence application go through the immigration rules.